Hi, Stefano Molea here, San Diego criminal defense lawyer and partner at the law office of David P. Shapiro, where we help good people regain control of their future when charged with a crime. And in today's video, I'm going to talk about what it really means to get ready for a trial when someone is accused of a crime. So as a criminal defense lawyer, of course, there are times where the case has to proceed to trial. And when that happens, there's certainly a process that begins far before the actual trial date. And that process is what I'm going to be talking about today. So obviously, the first step in the criminal process includes obviously the various hearings, the arraignment, the readiness conference on felonies, preliminary hearings. And during that process, you also get discovery, right? Meaning that the defense is entitled to all the evidence that the prosecution intends on using to try to prove the case. Other times, the defense can also ask for things that the prosecutor didn't get originally. The hope is that that evidence is going to provide greater perspective and greater context as to the case itself. But ultimately, once all that investigation and discovery stage is over, we have what we have as far as the evidence, we have what we have as far as the facts of the case. And when a case cannot resolve, meaning whether it gets dismissed or there's some sort of plea bargain, then the case proceeds to trial. And what I want to talk a little bit about sort of what is the process so that, if you have a case that's about to go to trial, you can kind of make an assessment about whether or not you feel informed about what the process really is and what it takes to get a case ready for trial. So aside from obviously thoroughly reviewing every piece of evidence that the prosecutor has, there's also potentially some investigation that the defense will do in preparation. And then ultimately, if that information that the defense gathers as part of their investigation is going to be shared with the prosecutor, that has to happen under California law within 30 days of the trial date. And so it's called a reciprocal discovery obligation, meaning obviously the prosecutor has an obligation to give the defense everything that they intend to use, including what we call Brady material, meaning anything that could potentially help or exonerate the defense, generally speaking. But then if we intend on presenting evidence, we have to also turn it over 30 days before trial. And aside from that investigation, once everything's complete, then there's, different lawyers do it differently. But for us and for most of the attorneys here at the law office of David P. Shapiro, we will create a trial binder. Right? And a trial binder is something that essentially gathers everything in a very organized fashion. And typically it's done by organizing a tab in a binder specific to each and every potential witness. And each tab is going to have literally everything related to that particular witness so that it can be studied, it could all be in one place. And when you're in trial and you're cross-examining that witness or direct examining that witness, you have everything in one place that's organized and you know where to look for it if there's any kind of issue during the trial itself. In addition to preparing sort of all the evidence in an organized way so that you can be prepared to find anything you need during the fast-paced process that trial tends to be, there's also subpoenas that sometimes have to be sent out. So if we want to call witnesses or want to have them ready to be called in case we need them, then we're going to want to send out subpoenas for us to be able to do that. And obviously, sometimes in some cases, there's going to be experts in addition to just lay person type of witnesses. And these experts are going to be sort of utilized, and by this time, right, if we're within 30 days of trial, the prosecution is going to know about the expert, is going to know about what the expert is likely to testify to, and vice versa. We'll know any expert that they intend on presenting. And getting that expert ready and having everything lined up to be able to effectively present the expert's testimony to the jury to help explain a complicated idea in a way that's digestible for the jury. And so those are the general sort of things that, as a defense lawyer, we worry about when getting ready for a trial, and hope that this perspective will give a little bit of insight into some of the things that goes into preparing for a trial. And if you have any questions, feel free to obviously leave them in the comments or give us a call here at the office. Again, Stefano Molea, partner at the law office of David P. Shapiro, 619-295 35, 55.